Florida in this honorable court.
Please be seated. Good morning and welcome to the First District Court of Appeal. We have one case on the docket this morning, University of Florida Board of Trustees and Shands Teaching Hospital and Clinics doing business as Shands Hospital versus Laura Commodi. Counsel, in light of the respondent's non-appearance here, you have 15 minutes to present and no requirement for a rebuttal. After the arguments, we invite counsel to join us in the rotunda for coffee. Counsel, if you're ready, you may proceed.
May it please the court, Christine Davis, on behalf of the petitioners, University of Florida Board of Trustees and Shands Teaching Hospital and Clinics. The issue before this court is whether plaintiff's pre-suit expert, an internal medicine doctor, an anti-aging doctor, is qualified to corroborate a claim against an advanced registered nurse practitioner specializing in neurosurgery. Under Florida's Medical Malpractice Act, to be qualified, the expert must comply with subsections 5 and 6 of Section 766-102. Florida courts have made clear that these statutory requirements must be taken literally, and they are not synonymous with physicians in different specialties corroborating, or physicians with different specialties who have provided similar treatment to the same areas of the body. As the 2013 amendments made clear, the trial court no longer has any discretion to qualify or disqualify an expert based on anything other than those explicit statutory requirements. Plaintiff's pre-suit expert here, Dr. DeStevens, did not satisfy any of these criteria. First, under Section 766-102-5C, that applies when an expert is corroborating a claim against a healthcare provider who's not a specialist or a general practitioner.
And counsel, if I may stop you there. So the question here is whether the expert here was qualified under the statute to render an opinion for purposes of pre-suit. And you're here on a petition for writ of certiorari, and you have to demonstrate that threshold, irreparable harm. One of the concerns I have is the statements in Williams v. Oken on this very point, and I'm going to read to counsel and would like you to address this, but there they said there was an expert affidavit, and again there was a dispute of whether it was the correct kind of expert. And the court said, Dr. Oken was afforded the process guaranteed by the statute because he received advance notice and an opportunity to examine the expert's claim before the filing of the lawsuit. Thus, a deprivation of process did not occur. But then they go on to say whether the trial court erred in finding Dr. Foster was a qualified expert under the statute is an issue of mere legal error that is insufficient to merit certiorari review. Why is this case different?
Several reasons. Oken was decided under the pre-2013 version of the statute. That statute required that an expert to be qualified to corroborate a claim against a defendant has practices in the same or similar specialty or has experience evaluating, treating, or diagnosing the same medical condition. The trial court thus had more discretion under that prior standard, prior 2013 standard, to weigh the evidence and determine whether the doctor was in fact practiced in a similar specialty or treated the same or similar medical condition. We no longer have that anymore. The issue in Oken, in addition to the portion you just read, was that you can't weigh the sufficiency of the evidence on certiorari, and they analogize that to the punitive damages statute. And
so are you suggesting there's no discretion for the trial court, I mean, in terms of determining whether an expert qualifies as an expert under the statute?
The trial court, that's what the cases have said, and that the discretion is gone. You apply this plain language of the statute to determine whether it's the same specialty or, in this instance, whether it's the same or similar health profession. So you look at the testimony of the doctor, his affidavit, and you can determine from that he is not qualified. So the difference between Oken versus Williams is that there was evidence that the trial court weighed to determine whether that pre-suit expert was qualified because of that different standard. Under this new standard, it's entirely different.
Okay.
And the court
what do you do with the statement by our court just last year in DeSantis versus FEA, where we were discussing the Williams case, and there again, if we said If the trial court follows the essential process guaranteed by law, like those statutorily guaranteed pre-suit requirements, a mere erroneous ruling that results from that process cannot establish a jurisdictionally necessary irreparable harm. What does that mean?
I don't think, well, applying it in the med-mal context, you have to qualify. You have to provide a pre-suit expert who is qualified under the statute. If you don't provide a qualified pre-suit expert opinion, it's the same as not providing an affidavit at all. So to read it that way would be taking the qualification provisions of the Medical Malpractice Act out of the statute, which is contrary to the plain language and contrary to the statutory scheme. So here, for example, if what you're saying is they followed the process, so they provide an affidavit from a pre-suit expert who's a family medicine practice doctor testifying against a cardiologist, as long as they followed the procedure, that's enough. That's certainly not what the law requires. The law requires same specialty, or with respect to someone who is not a specialist or general practitioner, it requires same or similar health profession. That you have to be qualified, otherwise you're gutting the purpose of the act.
So Oken comes out different now?
Oken would come out differently today, and it wouldn't be the same, there wouldn't be the same weighing of the sufficiency of the evidence. The standard would be completely different. And they would have looked at whether that affidavit, whether that doctor in Oken, who was, I believe, an emergency room physician, could testify against an orthopedic surgeon. I'm not sure if I have that exactly right. But it would definitely come out different today. The issues just aren't the same. You wouldn't even be weighing the same issues. You're not weighing the sufficiency of the evidence. You're looking at...
Well, in a sense, you are, right? I mean, under 6, does this expert have knowledge of the applicable standard of care for nurse practitioners? Have they been active in the clinical practice? At some point they are. At some point they will meet the threshold, and at some point they won't, right? And
Right.
is that's sort of a call that the trial judge is going to have to tease out and make.
Right, and I think you look at the record, and they can hold an evidentiary hearing. The Supreme Court has made clear that you can hold an evidentiary hearing to determine when you can't tell from the face of the affidavit whether the expert is qualified. You can hold an evidentiary hearing and determine whether, based on their testimony, whether they're qualified or not. And here, under subsection 6, which would be the whether you're qualified to opine on the standard of care for a nurse practitioner, you still have to satisfy the requirements of subsection 5. That's clear in the statute, and that would be subsection 5C, which I think Dr. DeStephen's own testimony indicated that he did not satisfy. The brief discusses a lot of his testimony on that. Subsection 6, he would have had to supervise an ARNP, and it can't just be any other ARNP. If you think...
Where does it say, I'm sorry, counsel, where does it say anything about supervision in subsection 6?
It says, subsection 6 says, through active clinical practice or the instruction of students, knowledge of the applicable standard of care for advanced registered nurse practitioners.
So it doesn't require actual I'm not sure I understand how it requires
I
actual
think that there's
supervision.
cases that talk about it being, that construe that as being a supervisory capacity, but you're right, the statute says through active clinical practice or instruction of students, knowledge of the applicable standard of care. And in this case, Dr. DeStephen had never worked with an ARNP in an office or clinical setting, certainly not a surgical setting. He never had ARNPs work under him. He even made clear in his testimony why he wouldn't be qualified through active clinical practice or instruction of students to testify as to this ARNP, because he says the person who would be the most qualified is the neurosurgeon himself. He said that ARNPs operate at the behest of the physician that they are working under. It's the primary responsibility of that physician to tell the ARNP what the physician wants the ARNP to do. In the case of post-operative wound care, it's up to the neurosurgeon to teach everything that the neurosurgeon feels is necessary to that ARNP to provide proper post-operative wound care. It's incumbent on the neurosurgeon to train the ARNP for anything and everything that is reliant on post-operative wound care. And the standard of care is based on what the surgeon chooses it to be. The standard of care of an ARNP is what the surgeon chooses it to be. He doesn't have any experience in that area. He has no experience in neurosurgery or surgery in general. At most, he has done minor surgery requiring stitches such as mole removals. So he's not qualified to say what should happen after a neurosurgical procedure. he attempted to testify what would be excessive pain after a neurosurgical procedure. He has no qualifications to do that. He's never performed surgery before in his life, and he's never supervised an ARNP or.
But 6 only talks in terms of having knowledge of the applicable standard of care for nurse practitioners. So to the extent, I mean, I get to the extent that he's not a specialist in the same way that the doctor is here. But does he have knowledge of what the standards are for
Not in
nurse
this case.
practitioners? That seems like a more difficult
Not in this
factual
case,
call.
because for number one, they have to satisfy the requirements of subsection 5, and he can't do that. Same or similar health profession, he can't do that.
Why is that?
Why can't he satisfy 5C?
Yes.
Because he does not practice in the same or have any experience in the same or similar health profession as the ARNP. And health profession, while not defined in the statute, or in any cases that I've found, has to be read, when you look at the context of the statute, it has to be read in the context of the entire statute. You couldn't have, for example, take a family practice doctor who worked in a private practice and sees families, and he supervises ARNPs and RNs who take blood pressure, take blood, take the history, all of the things that happen in a practice, family law practice. Just because he supervises nurses in that setting does not mean he's qualified at all to testify what a neurosurgical ARNP should do after surgery.
Counsel, well, first of all, I guess I have a preliminary question. I notice you've talked exclusively about 5C. Do you contend that the nurse practitioner was a specialist under 5A?
In my brief, I said that I think it could be both ways, and the case law is not very clear. I think she could be considered a specialist. She is an ARNP with specialty and special training in neurosurgery. So to the extent she's a specialist, she would definitely not qualify under 5A.
So I guess this question would apply whether you're going under 5A or 5C. You know, I looked at Chapter 464 as carefully as I could to determine the types of advanced practice registered nurses. And I presume I've heard a lot of both briefs, the order they talk about advanced registered nurse practitioner. There's actually no such thing in Florida law. You have the advanced practice registered nurses. There's several different types. You've got the sort of nurse midwives, nurse anesthetists, nurse practitioners, which I presume is what we're talking about here. But is there any kind of a subspecialty that would say, no, this isn't just a nurse practitioner. This is a neurosurgical nurse practitioner. That is her specialty, and that is what the pre-suit expert needs to have information about.
I think when you're looking at the statute as a whole and how it applies, you look at what that ARNP does. She specializes solely in surgery and specifically in neurosurgery. So while the statute doesn't set forth every single criteria of subsets of specialty, you have to at least have knowledge of the standard of care of what that nurse was doing and what she should have done, what her standard of care was. And Dr. DeStevens in his testimony admitted that he had never done that before. He doesn't know anything. He does not handle neurosurgery. He has not handled, he has not trained nurses or worked with nurses handling neurosurgery. When he worked as a hospitalist, he worked with nurses, but nothing to do with surgical. So you would be expanding these criteria, the strict criteria in the statute, to something that is far beyond what the statute contemplates, as made clear by the 2013 amendments to the statute. One thing as far as same or similar health profession, to the extent that you mentioned that, and there isn't a statute or case that I found that specifically identifies that, but there is a decision, Holmes Regional Medical Center versus Worth. It's a 50 CA decision. And it's the only one I found where they actually talk about what a health profession would be. And then Judge Lawson wrote a dissent in that case, and he said, in that case, the parties agreed. It was a case where they alleged negligence of nurses, clinical hospital nurses in a hospital setting. And in that case, they agreed that clinical hospital nursing was a unique health profession. He then said, though, that he didn't see how a nurse who had spent the previous decade in a patient rehab setting would be qualified to render an opinion as the standard of care for inpatient hospital monitoring. That is the only description of what a similar health profession would be. But if you look at 766-202 subsection 6, a medical expert is someone duly and regularly engaged in the practice of his or her profession and who holds a healthcare professional degree and satisfies section 766-102. So that health profession would be what you get your degree in, what you specialize in. And here, he has no experience whatsoever with neurosurgery, surgery, wound abscesses. At most, the most he said was that I have seen a wound abscess and I can tell what it looks like when it's red and swollen. He's never treated one. He has never treated a post-op surgical patient. He at most treats them when they're in the hospital, but nothing related to surgery. He's made clear that that is absolutely within the bounds of the surgeon. And so in this case, unlike the cases we cited in our brief, Nicholas from this court, which was under the more liberal standard or more lenient standard, pre-2013, they were not qualified, even though they practiced in a similar area. In the Clare versus Lynch case, they had, the doctors both practiced foot and ankle surgery, but one was a podiatrist and one was an orthopedic surgeon, and those were not the same. Here, it's even more different.
Okay. Thank you, counsel. This court will stand adjourned.
All rise.